Great. Thanks everybody for being on today. Thanks for joining our series. We're hoping these sessions are keeping us connected during this difficult time. We've made all of the previous ones publicly available. We'll make this publicly available. Just letting you know a little more about IEC. We were founded in 1975 by a group of dedicated grassroots environmentalists, and we lead issue advocacy campaigns by allowing environmental organizations to pool their resources and create a higher profile for environmental issues. IEC represents more than 90 environmental and community organizations and nearly 400 individual members in Illinois. If you're not a member and are able to give, please consider today using the link in the chat box. I'm Jen Walling, the Executive Director of IEC, and in a second, I'll be introducing the folks that are speaker today. Just a few housekeeping items. All attendees are muted by default. If you joined via Zoom, please use the chat function to ask questions. Time permitting, we will take live questions at the end of session, but probably we'll just get to the ones in the chat box. For those joining by a phone, you can use *9 to raise your hand. And I'm going to introduce our speaker to you, who I am very excited about. We work a lot with the Attorney General's office because they play such an important role in overseeing environmental issues. And our speaker today, Daniel Rottenberg, is an Assistant Attorney General in the Illinois Attorney General's Environmental Enforcement Division. In his position, Daniel litigates environmental enforcement cases in state and federal court, as well as before the Illinois Pollution Control Board, on behalf of the people of the state of Illinois. He also coordinates Illinois' involvement in federal multi-state legislative policy and litigation matters. Prior to joining the AG's office, Daniel clerked for the Honorable Lynn M. Egan and completed a climate litigation fellowship at NRDC, where he was also involved at in the YP board of the Illinois Environmental Council. He's previously worked in each of the 3 branches of federal government. He's originally from Iowa and has studied environmental studies at the University of Oregon before earning his law degree at Lewis and Clark. So very excited to have Daniel on. He's going to present on the role of the Attorney General. I know you guys, there's a lot of you on. I'm going to put the CLE link in a second. So if you want CLE from this presentation, just follow the link. And if the link is not working, just send me an email and I will send you the link. But I think we fixed that for those of you who have not been involved in the past. But I'll add the link shortly and then I'll add it later. So if you want your hour of CLE credit from this, just fill that out. And I will also I know Daniel will enforce this, but today we're talking about the role of the Attorney General's office in enforcement. Daniel cannot talk about any ongoing cases or any of the strategy used to settle any cases, that sort of thing. So if you can keep your questions to things related to, in general, how things are enforced, and not ask specific questions about ongoing litigation, that would be appreciated. If I see one that I know is about ongoing litigation, I'm just not going to ask it. But just please be conscious of that in your questions. There are limitations to what he can answer, but we're really excited to present more on the role of the Attorney General's office because it is such an important part of environmental enforcement. So I'm going to go on mute and Daniel is going to take it away. So thank you, Daniel.
Well, thank you so much, Jen, and thank you for everything that you do and for IEC's important work. It's wonderful to be with all of you, and it's a privilege for me to do this presentation in multiple respects. The first is that, as Jen touched on, I was previously on the IEC YP board, and until I joined the AG's office in October of 2017, and I left the YP board due to potential conflicts. However, the YP board was a great introduction to the work that IEC does, and I highly recommend it to any young professionals on this seminar who are interested in getting involved in environmental issues and giving back. The second reason I'm so happy to be here is that I'm extremely proud of the work that we do at the Illinois Attorney General's Office Environmental Enforcement Division. And I'm excited to shed some light on that work with all of you. I'm sure familiarity with the work that the AG's office does varies amongst this group, but just know that if you're uncertain of the role of the Attorney General's office in environmental enforcement, you're not alone. I personally developed a passion for environmental advocacy and environmental policy as an undergrad, and even after studying environmental policy and graduating and working for Congress and attending law school to study environmental law in particular, I still was not fully informed of the role of attorneys general's offices. It wasn't until I started at NRDC and started working with a coalition of state AGs on defending President Obama's climate initiatives that I was introduced to the work that AGs do at the national level. And it really wasn't until I joined the Illinois Attorney General's office and have been fortunate to work on some matters such as the Stereogenics matter and the 401 North Wabash or Trump Tower matter and the recent Hillco matter, that I fully grasped how vital the AG's role is at the state level in enforcing state environmental law. So hopefully after this presentation, you too will have a better understanding of the vital function of the AG's office plays in protecting human health and the environment through the enforcement of state and federal environmental law. So beginning with some background on the Illinois Attorney General's office, the Attorney General for the state of Illinois is Kwame Raoul. He took office in January of 2019. As many of you know, Lisa Madigan was previously the Attorney General for 16 years prior to Attorney General Raoul taking office. It's well established that the Illinois Attorney General is the chief legal officer of the state of Illinois. That is in the Illinois Constitution in Article 5, Section 15. And as such, the duties of the Attorney General have been found to include representing the people of the state of Illinois and all state agencies. We have approximately 770 employees in the Illinois Attorney General's office, of which approximately 400 are attorneys. The environmental division is its own division within the AG's office, and Matthew Dunn is the division chief for the environmental division. And the division is split into two bureaus, a northern bureau, which is out of Chicago, and a southern bureau in Springfield. The Northern Bureau has 13 attorneys, and Elizabeth Wallace is the bureau chief. And the Southern Bureau has 10 attorneys, and Andrew Armstrong is the bureau chief in Springfield. Roughly speaking, the Southern Bureau is responsible for the southern 2/3 of the state of Illinois, or all parts of the state south of Kankakee County's southern border, other than a small piece of LaSalle County. We also have an environmental crimes bureau, but that bureau is no longer part of the environmental division. It is part of the criminal division. So as an assistant AG in the environmental division, I will be speaking about our civil enforcement of environmental laws today. Grounding our work in the Constitution, many of you know that the Illinois Constitution of 1970, Article 11, Section 2, provides that every citizen has a right to a healthful environment. And Section 1 of Article 11 declares it to be the public policy of the state to provide and maintain a healthful environment for the benefit of future generations. And the Illinois Supreme Court has held on multiple occasions that the Attorney General has an obligation to represent the interests of the people of the state so as to protect this right. I included People versus NL Industries, which is also in the materials for this CLE. There's also Pioneer Processing versus EPA that touches on this. And these are cases that discuss the authority and role of the Attorney General's office. But importantly, it is this obligation to represent the interests of the people, to protect the people's right to a healthful environment. And, you know, I've heard environmental advocacy and environmental policy work as described as four-dimensional chess, with the dimensions being regulatory, legal, legislative, and public engagement. And at the AG's office, we're active in each of these dimensions to meet the obligation to ensure a healthful environment. We participate in administrative proceedings. We actively litigate enforcement and administrative review cases in state and federal court and before the Illinois Pollution Control Board. And we review state and federal legislation dealing with environmental and public health issues. And we engage with the public to identify and resolve environmental and public health issues. As an assistant AG in the environmental division, my presentation is going to focus on the regulatory and legal work that we do. The majority of the work that we do in the environmental division is enforcing the provisions of the Environmental Protection Act and the regulations or rules adopted under the act. So in 1970, the same year as the constitutional right to a healthful environment, the General Assembly enacted the Illinois Environmental Protection Act. And in fact, they enacted it in fulfillment of the constitutional requirement. And the Illinois Protection Act repealed several statutes, including the Sanitary Water Board Act and the Illinois Air Pollution Control Act. And in their place, it established a unified statewide program to restore, protect, and enhance the quality of the environment in the state. The act also created the Illinois Environmental Protection Agency, or IEPA. And the act includes two sections that provide authority for the Attorney General's office to enforce environmental laws, or excuse me, the provisions of the Environmental Protection Act and the regulations adopted under the act. And the Illinois Supreme Court has held that the Attorney General has the authority to file actions before both the Illinois Pollution Control Board and circuit courts to redress violations of the act. And circuit courts and the board have concurrent jurisdiction. And, you know, I'll just say that whether we file a complaint before the board or the circuit court is a fact-specific decision that we make, you know, along with our client agency, just based on the facts of a particular case. But sections 42 and 43 of the Environmental Protection Act deal with our authority to bring cases in circuit court. And you will notice that the state's attorney of the county in which the violation occurred is mentioned. So the state's attorney also has authority under the act, and we will, in particular, in certain cases, work jointly with the state's attorney. Stereogenics, the Stereogenics enforcement matter was an example of this, where DuPage County joined the complaint, and we worked with the DuPage County State's Attorney's Office throughout that matter. And both sections 42 and 43 give the Attorney General authority to seek injunctive relief against any individual causing environmental damage. The difference between the sections is that 43A deals with substantial dangers to the environment and allows the Attorney General's office to go in, even ex parte, and get an immediate injunction to halt a discharge. So an example of this would be a gas station that is leaking gasoline into a sewer system. You know, in that case, we could get a referral from IEPA identifying the issue, or we could go in and get an injunction to immediately require corrective actions to stop that discharge. Complaints filed before the board are pursuant to Section 31C1 of the Act, which I didn't include, but that's just for your own knowledge. And common law remedies are also available to abate and enjoin public nuisances caused by pollution. So again, going to the Stereogenics matter, this was a count in that complaint was a public nuisance count. So even setting aside the Environmental Protection Act, common law remedies are still available. Our clients are generally speaking the agencies, environmental agencies of the state of Illinois, but you will notice that every complaint that we file in state court is on behalf of the people of the state of Illinois. The people are our clients. Even if we get a referral from an agency and we're working with the attorneys in that agency in-house and we're acting as that agency's law firm in a sense, our client is still the people in the caption of a complaint. So first and foremost, we bring cases on behalf of the people. When we file a complaint, the caption is people of the state of Illinois, ex-rel Kwame Raoul, Attorney General of the state of Illinois. And ex-rel is a Latin phrase, you know, roughly meaning on behalf of. And so the Attorney General's office is filing on behalf of the people of the state of Illinois. And we have at the Attorney General's office, going back to Section 42, we have authority to bring cases on our own motion. So we can bring a case to enforce the provisions of the Environmental Protection Act on our own motion. But the majority of our cases are brought on behalf of IEPA. And most of you know that IEPA is the state agency with the primary responsibility for carrying out state and federal environmental laws and regulations in the state of Illinois through a system of permits, inspections, compliance, and enforcement. And you know, they also regulate public water supplies, wastewater treatment and sewer systems. And so they're really the eyes and ears on the ground with respect to environmental issues in Illinois. And I've included some statistics in this slide looking at 2019. And these numbers, of course, vary year to year. They can be more, they can be less, but I included 2019, the most recent year for which we have numbers. And IEPA referred 94 cases for enforcement. About 17 were air, 28 water, 48 land. So an air enforcement case could be constructing or modifying an air pollution source or control device without a permit, or a record-keeping violation like failing to submit an annual emissions report as required under a permit and the Environmental Protection Act. Water could be a violation of a national pollutant discharge elimination system permit, or NPDES permit. Land cases could be open dumping, other land contamination cases. So that's just a little taste of the kind of cases we get. The process with Illinois EPA starts with IEPA identifying a violation. So again, it could be through an inspection. IEPA identifies that a source has constructed a new piece of equipment that they didn't have a permit, that they're operating a piece of equipment that they don't have a permit to operate, that they're emitting a contaminant for which they're not permitted, or a contaminant in amounts greater than they're allowed to. But then IEPA could also identify a record-keeping violation, again, like a monitoring or reporting requirement that was not complied with. And once IEPA identifies a violation, Section 31 of the Environmental Protection Act sets forth the process for IEPA to go through after identifying a violation. And that's informally known as the Section 31 process. And this section dictates, how the parties are to be notified of alleged violations, and how they may respond to avoid potential liability, and how IEPA must proceed before referring a violation to our office. So the Section 31 process occurs before we receive a referral, and that's a written violation notice that must be responded to. Sometimes parties will propose compliance commitment agreements. Sometimes they won't reply to the violation notice at all. So various things can occur during that Section 131 process. But if after that process, IEPA determines that it is appropriate to refer the matter to the Attorney General's office for enforcement, they will do so, and they will send the entity a notice of intent to pursue legal action letter and refer the violation or violations to our office. Once we receive a referral from a client agency, we'll proceed with the enforcement matter. We'll investigate the alleged violations. We'll work with the client agency to determine background on the violations, what we need to prove violations. We'll get started, with a potential complaint. We'll reach out to the entity, potentially begin settlement negotiations. And so, we'll take any steps necessary on our end to, move toward a resolution of the violations. And that can include vigorously litigating, although a majority of our cases do settle. That being said, we had a trial last year, and we're prepared, and we do vigorously litigate motion practice and all the way to trial, discovery, you name it. And just to touch on a few of the other agencies that we get referrals from, Office of the Illinois State Fire Marshal. These are underground storage tank cases where there's a storage tank that needs to come out. We have Dry Cleaner Environmental Response Trust Fund Council cases, and these are the fees and licensing requirements for dry cleaners in the state of Illinois. And I'll just say that as of July 1st, 2020, the administration of the Dry Cleaner Environmental Response Trust Fund will be transferred to IEPA from the council. And that was pursuant to legislation passed by the General Assembly, SB 171. IDNR referrals, again, generally speaking, can be natural resource damage cases such as fish kills. And so we get referrals from various agencies, but again, we can also bring enforcement actions on our own motion. So looking at some numbers from 2019, we filed 108 complaints. 75 of those were filed on behalf of IEPA. We entered into 58 settlement agreements. We collected $2,625,902, and the representative cost to defendants was $31,560,088. Again, these numbers fluctuate year to year. Some years they can be much more. So that's some background on our state environmental work. That is the bread and butter of the environmental division's work. The majority of our attorneys stay quite busy litigating, enforcing state environmental laws, and representing our client agencies. But another facet of the AG's work and the work in the environmental division is federal and multi-state work in coordination with other state attorneys general, and sometimes cases that we bring in federal court to enforce federal environmental laws. So as most, if not all of you are well aware, a main priority of the current federal administration has been to reverse environmental and public health rules. I pulled this number last week. The New York Times has a tracker. I have a link here. And when I looked, they had 100 rollbacks listed. 66 were completed and 34 in progress on their tracker. And those of you who are familiar with environmental law know that when you have a proposed rollback, it starts with a proposed rule, and they'll take comment on that rule, and then if they decide to move forward, it'll become a final rule that is subject to judicial review. So even if it's under the completed list, that does not mean that there's not pending litigation to reverse that rule. And I'll say that our success rate in challenging final actions by the Trump administration, both the NGOs and state attorneys general, have been quite high. So, you know, don't see that 66 completed and think that it's a done deal, because we're in court on a lot of those. And then in progress, you know, that means that they're taking comment, and we have drafted or joined more than 50 comments during this administration, and we've brought or joined more than 25 lawsuits challenging final rules or actions. And I'm going to walk through some of the higher profile cases that we're involved in, but you know, we're engaged in many other issues that are not listed here. Pesticides like neonicotinoids, PFAS contamination, methane emissions from landfills, and you can Google NYU State Impact Center, and that is an organization out of NYU that tracks all of the AG actions to confront these environmental public health rollbacks. And you can categorize that by state, so you can look at directly at Illinois. Again, I included some of them in the materials for this CLE, but again, that's NYU State Impact Center. And, you know, in addition to administrative comments and lawsuits, I'll say, you know, we also do amicus briefs. We write letters to Congress. such as supporting increased US EPA funding or bans on asbestos or HFCs, the powerful climate pollutants used in refrigeration. So state AG offices are engaged at the federal level in many ways, but walking through some of the major litigation, beginning with the so-called Affordable Clean Energy Rule. So oftentimes sometimes you will see a state, you can see California on a couple of these, but if you see American Lung Association, that means that our lawsuit was consolidated with other lawsuits. So this is an effort that's led by the New York AG's office. 23 attorneys general are involved in the litigation over the Affordable Clean Energy Rule, but cities are also involved in this one, including the city of Chicago. And this is a final rule that is the Trump administration's replacement for the Obama administration's Clean Power Plan, which was the nation's first ever regulation of greenhouse gases or CO2 from the nation's power plants. And the Trump administration's plan does very little, and then part of the rule was actually 3 rules, and one of them repealed the Clean Power Plan. So that's a challenge that's in front of the DC Circuit, and you'll see that a number of these are in front of the DC Circuit, and that's because the Clean Air Act contains a provision that requires all challenges to nationally applicable Clean Air Act rules be brought in front of the U.S. Court of Appeals for the DC Circuit. So the DC Circuit is a bit of a specialized Clean Air Act court. And so you'll see a lot of challenges to these national Clean Air Act rules brought in front of the DC Circuit. Again, so-called safe vehicles rule. This is the Trump administration's rollback of the Obama administration's vehicle emission standards. 24 attorneys general are involved in this one, and the rule weakens fuel efficiency and greenhouse gas emission standards for passenger vehicles and light trucks. It mandates just a 1.5% annual improvement in fuel efficiency, which is well below the 5% annual improvement required under the Obama administration standards. And this is also a multi-part rule where there was a part 1 that revoked California's waiver and ability to set its own standards, and then part 2 was the actual weakened standards. The case that I have listed here is our challenge to the weakened standards. So that's one that we are working on with 23 other states. Waters of the United States, I actually attended a terrific IEC Lunch and Learn on the Waters of the United States. So those of you who are on who also joined that one know the background on this case. This is the jurisdictional trigger for the Clean Water Act. What is a water of the United States? 18 attorneys general are involved in this one. And the rule is called the Navigable Waters Protection Rule, and it eliminated federal protections for more than half of the nation's wetlands and hundreds of thousands of miles of upland streams. And so it dramatically narrowed the jurisdiction of the Clean Water Act by narrowing what is considered to be a water of the United States. Ozone designations. This is a case that actually was not brought in collaboration with other attorneys general. So I mentioned that, we can and do get involved outside of state environmental enforcement, which is the vast majority of what we do. But in this case, we got involved in federal court to challenge US EPA's designation of counties in Wisconsin, Indiana, and Illinois as in attainment with the 2015 standard for ground level ozone or smog. So we filed a lawsuit in the DC Circuit again because the designations were a nationally applicable rule. And several other NGOs also filed lawsuits, including Clean Wisconsin, who filed first, and thus the consolidated case was under their caption. But Clean Wisconsin and ELPC and Sierra Club and Respiratory Health Association and others also challenged different designations throughout the United States. And we were consolidated in the DC Circuit. And we argued that the designations of attainment for these certain counties in southeast Wisconsin and then Monroe County in Illinois and McHenry and some county, Lake and Porter in Indiana, we argued that despite technical staff at US EPA recommending that the agency designate these counties as in non-attainment with the 2015 standard, political staff at US EPA overrode that decision and decided to designate them attainment. And I had the opportunity to brief and argue this case in front of the DC Circuit in November of last year, and we are waiting on an opinion. And it will be a very interesting opinion because in what I believe is unprecedented fashion, US EPA actually declined to defend a number of the designations. So it'll be interesting to see what the court does, how it sends those back to US EPA, if it requires US EPA to redesignate, if so, if they put a timeline on them. So we're eagerly awaiting that opinion, and we hope that it's a good one for the health of Illinoisans. The next one is MATS, and this is the mercury air toxic standards. The lawsuit that I listed is actually from 2016, and you'll see that EPA is a defendant in that case. And that is because we actually intervened in support of EPA back in 2016 in that case, when EPA was defending its decision to find that it was appropriate and necessary to regulate mercury and other air toxics from under the Clean Air Act from coal-fired power plants. The Trump administration has now reversed that determination that it's appropriate and necessary, and found that it is not appropriate and necessary to regulate mercury and other toxic air pollutants from coal-fired power plants. And although they argue that the standards remain in place, by removing the legal underpinning for the standards, which is the appropriate and necessary determination, the administration is seriously undermining that rule and those standards. And this was a landmark rule that the Illinois Attorney General's office worked on for years, and 22 attorneys general commented back in April of 19 that EPA should not finalize the reversal of the appropriate and necessary finding. They have finalized it despite those comments, and so petitions for review challenging this rule are due before the DC Circuit by July 22nd, 2020. The last one I included is a recent case that was just filed before the Southern District of New York. And in fact, just this Monday, the state of Illinois, along with the state of New York and 7 other attorneys general offices, filed a preliminary injunction to halt the US EPA's what we call COVID non-enforcement policy. And so recently US EPA put out guidance that suspending environmental enforcement actions under a range of environmental laws. So basically finding that sources can stop complying with monitoring and reporting requirements without informing the public. And so the public has no idea whether sources are polluting more than they're allowed to, because the sources aren't required to produce those comply with monitoring and reporting requirements under the Clean Air Act, for example. So we filed a preliminary injunction motion on Monday, and we will brief that, and that effort is being led by New York. So that's some background on some notable multi-state cases that we are involved in at the Attorney General's office. And I hope by running through those cases, I didn't overshadow, again, the vast majority of the work we do, which is representing our client agencies and bringing enforcement actions in state court. But, again, I'll say that before I joined the office, I was familiar with some of the national work, not as much of the state work. And so I think it's important to know that, again, when you think about those different dimensions of environmental work, as the state's top lawyer, the Attorney General is working on a number of fronts to protect human health and the environment for citizens of the state of Illinois. So that's all I have. Happy to answer questions that I'm able to answer.
Sure. Thanks, Daniel. And I got a couple in the chat. Let me start with the one that's a little more technical. With respect to federal appellate legislation, how do appellate counsel at the Attorney General's office, who may have no subject matter expertise in a given issue, work with subject matter experts within the Office of the Attorney General when the matter is in federal court, such as in the case of a lawsuit against a state agency with appellate counsel representing that agency? So how does that relationship work? And let me know if you need me to repeat that or try to summarize that.
Well, I'll take a shot at it. We do have an extremely talented and competent appellate division at the state AG's office who handle our state appellate work. So if an issue from one of our enforcement cases, a legal issue, goes up on appeal before the appellate court or the Illinois Supreme Court, we'll work as subject matter experts with appellate counsel, providing background on our case, but they will litigate the case and argue it. The DC Circuit case that I argued in November was a little different because that was a federal appellate case that we brought directly in the DC Circuit because the Clean Air Act has that provision for direct appeal. So it wasn't a legal issue that went up on appeal from trial court. In the environmental division, we bring our cases in circuit court, we litigate them through trial as necessary, and then if there are legal issues that go up on appeal, that'll be handled by the appellate division. Again, the Clean Wisconsin ozone designation case was a little different because that was really a federal environmental enforcement action that we brought against US EPA. And so our division handled it, although, I worked with Solicitor General's office to prepare for that argument. And, they're a huge resource on appellate matters.
Okay, hopefully you can answer some of this, but Delia had typed into the chat. I'm going to try to add to her questions. If the Illinois Environmental Protection Agency is to protect folks, why is it the burden of proof of pollution falls on communities? And she also asked how many cases has the AG's office worked with. the community in supplemental environmental projects versus violation money going back into the state. And I wonder, like, maybe, and you guys can type in the chat if you want, Delia, on this. Maybe, like, without conferring legal advice to communities, maybe one of the ways that you can answer this is, do you have any advice on, like, if a community notices an environmental violation in their community, how would they get it looked at, and what role can community organizations play in working with the Attorney General's office? Like, is there communication that happens between your office and a local community group that can be part of, like, a settlement in general? Does that make sense? And just, I think those were the things Celia was asking, if maybe you can just give some thoughts on.
Yeah, happy to provide some thoughts. I'll say the lines are open between the Attorney General's office and the public. We have an attorney each month that is responsible for taking citizen calls. And so, you know, when I'm on duty for that, I talk to folks who are concerned about all kinds of things, you know, a pesticide that may be sprayed on their, you know, property, or things that they observe, something they're smelling. So, you know, we're taking in constituent calls directly at the environmental division. We also have our constituent services division that takes in correspondence directly to the Attorney General, and if it's related to an environmental issue, it may get routed to the environmental division, and we will respond and reach out and handle that accordingly. Sometimes, as part of our settlements, again, working with our client agency and the defendant, there can be a supplemental environmental project as part of a settlement. And then also for violations of NPDES permits, there can be comment from the public. And so, you know, we're always happy to hear from the public. By its nature, you know, litigation is privileged and confidential, which, you know, really restricts in litigation the amount that we're able to share with folks who aren't involved in the litigation. But again, the lines are open, and we're always happy to hear from the public. I hope I at least touched on the question.
Yeah, I think that's been good. So, and folks can feel free to follow up in this. We'll take a couple more questions. So Faith had asked, I understand IEPA's enforcement budget has been reduced over the past 10 to 15 years. How do you think that has affected the AG's ability to bring enforcement actions on behalf of IEPA or referrals? Has the environmental budget been cut similarly? Just anything that you can talk about. Do you think you need more resources?
That's not something that I can comment on as an assistant AG. I think the numbers are public. The referrals to our office have varied from year to year, and IEPA is our client. So, you know, that's not something I can talk about.
Well, thanks. Elliot had asked, I don't know if you're following the recent federal ruling on Dicamba, and if you guys have any work that you're doing on the federal Dicamba ruling.
Yeah, so we are part of the federal multi-state TSCA group.
Some background there, because there might not be background. Just not like what it is.
Yeah, I think this is a registration under FIFRA, and was it from Elliot? Is that? Yeah, so you can feel free to provide more background if I'm missing it. You know, I'm not a subject matter expert on this, but I know that we are part of the TSCA FIFRA multi-state group. We recently joined multi-state comments on a number of pesticides, and you'll be able to find that on the that NYU State Impact Center. But if you want to reach out to me, I could send you those comments as well.
Great.
And if it's up, and if I'm confused and it's not something we're engaged in, you know, feel free to let me know or let the office know that it's something that you're interested in.
Yeah. So related to that environmental justice question, does the Attorney General's office take any measures to proactively reach out to communities affected by facilities subject to enforcement? And if not, why?
Well, you know, I would say my role there is limited. So again, I can't really comment on the office's efforts. You know, we have a number of different divisions that are actively engaged with the public, you know, and in the environmental division, generally what we do is bring law, you know, do our legal work, enforcing state law and dealing with referrals. And so, you know, I would probably direct that one to other divisions. Not to say that it's not important or something that we care a lot about. It's just not part of my role as an AAG.
Well, I mean, are there any, just like adding it to his question a little bit, I mean, are there ever any times where your litigation might involve trying to find a specific person or property that might have been impacted by pollution?
It could, you know, if you know, generally, and this is something I could have talked more about, you know, as our client, IEPA provides the technical support that we need generally to prove violations that they refer. But if we bring something on our own motion, or if we need witnesses, you know, we can go out into the community, find folks. You know, we're always interested in engaging with folks who are affected by pollution in the state, because it's our job to, you know, address it. And so, yeah, we can potentially reach out to folks if you know, if we're working toward a settlement and we want to know what's been done and or what hasn't been done or what the community may be looking for. You know, we'll potentially find folks to engage with in the community. You know, as you know, Jen, the Stereogenics matter, the community was very involved there. Again, confidentiality issues prevented certain communications with respect to the litigation, but with respect to the community's concerns and what the community was looking for, you know, that's something that we always wanted to hear about.
So in related that you brought up confidential information, there was another question here, just in process, are there any judicial exceptions for sharing confidential information obtained during litigation with the people of Illinois for the AG, since the AG's clients are the people of Illinois? So would that differ from a suit that might be private attorneys?
Yeah, that's really interesting. No, not that I'm aware of. So that's that kind of interesting situation where our client agency will be IEPA, and for, you know, litigation purposes, our communications would be attorney-client with them, you know, but ultimately the action is brought on behalf of the people. But that doesn't mean that, you know, every citizen of Illinois is then rolled into that, even though that's who we're litigating on behalf of ultimately.
That's really interesting. And there's I think these will probably be the last two since we just have a few minutes left, but I'll do one and then the other. Does the Assistant Attorney General agree to broad protective orders, or does it take efforts to enter into a narrow protective order? I don't know if I necessarily understand that question. Do you need more, Daniel, or does that make sense?
A protective order for like discovery purposes, like in a narrow sense, or like a final order, like a settlement order. You know, if it's the latter, you know, the relief, types of injunctive relief that we may be seeking in a case can range from broad to narrow. You know, it's, you know, cease and desist from future violations of the act, or send a permit application in by this date. I mean, whatever injunctive relief is required to resolve the alleged violations are what we're going to be going for. Protective order also refers to, you know, specific protective order in discovery and in litigation. I'm not sure quite if that was where the question was going. I'm not sure I can quite answer that.
I didn't quite. So Jeffrey, if you want to add any more detail, but hopefully that answered your question. And I can always, you know, connect you later.
Yeah, yeah, definitely.
And I guess as much as you can give on this, Faith had asked, just do you have any status updates on the Stereogenics case? What does the public know about it?
Well, Stereogenics decided that it wasn't going to resume operations. And so they still need to comply with our settlement agreement until it eventually would go away, because they are not resuming. They decided that they were not going to reopen their facility, but they still need to do the environmentally beneficial project that they signed up for, and otherwise comply with the order while it's in existence. But they decided that they would close the facility and not reopen it, rather than comply with the, well, not necessarily rather than, I mean, I'm not going to speak for them, but they did not implement the control measures required by the settlement. They decided to close their facility.
Yeah, I think that is great. So I just want to, I think that's good. We're at 12:58, so I think we're gonna end here, but I do have the correct CLE link that is in there now, so please definitely go to that link. And I want to let you guys know, we're not doing this every day like we were in May, but people have really enjoyed doing this. We do typing into the chat box now, June 16th, we have a really excellent webinar that Elliot's facilitating on the food system that looks at how COVID and the pandemic have been impacting food. For those of you who are attorneys, on the 19th, we have ICC, Illinois Commerce Commission member Maria Bocanegra, who is going to present on how the ICC interacts with environmental protection. And on the 24th, Ann McKibben is going to talk about energy efficiency laws. So a couple more CLEs coming up, and then we're basically every Thursday or so going to do these for a while out because people had interest. I also encourage, if anybody is really interested in presenting, let me know. Daniel has been on several of these presentations in the past. We will have a link available soon, Kara, so I will put that up. So thank you again, Daniel, for presenting. I think that was really interesting. We'll have a recording of this up on our YouTube channel pretty shortly. Make sure you fill out your CLE link and you'll be getting a certificate from me within a couple of days. Oh, there is the calendar for the upcoming ones. So again, thank you so much, Daniel. I think that was really fabulous. Thanks for answering our questions and helping us understand the really important role that you play in the office and the Attorney General plays in environmental protection. So thanks everybody for being on, and I hope that we will have you soon. So thanks, bye everybody.